Hi, welcome to the Front of the Court Smile video. My name is Valentina Barashai and I'm one of the directors, part of the management team here at Front of the Court.
Good afternoon. My name is David Falk. I'm one of the referees here at Front of the Court.
And I'm Lena Germain, one of the judicial service officers here at the Front of the Court.
One of the purposes of this program is to give people that are going through divorce cases or other family law cases an overview of what the Front of the Court is and what we do. So for people who haven't had prior experience, or this may be their first court experience, the Front of the Court is a separate division of the 16th Judicial Circuit Family Court. And we basically serve two functions. We're governed by both federal and state law, so there are certain things and processes that we're required to follow. But in general, there's two basic functions of the Front of the Court. One is we serve as an investigative body for the Family Court Division, and that entails hearing motions, conducting other evidentiary hearings for the court, and conducting certain types of investigations that are part of a divorce or custody action. The second general function that we have is we are the enforcement arm for the Circuit Court Family Division, and we primarily will enforce orders regarding child support, parenting time, custody, medical insurance and health care expense issues, and spousal support. One point that I would like to make about the investigative function that we have is a lot of people misunderstand. We are not a law enforcement agency. We are not child protective services. Our investigative functions are based on what is presented to us as part of a pending case before the court for either divorce or custody. So with that, Val's going to explain a little bit more about the general operation of the Front of the Court.
All right, so the Front of the Court, which is the department head of the Front of the Court, is Thomas Blome. Our management team is made up of 3 additional directors: Brian Nicholas, who is our chief referee, Laura Keith, who is the enforcement division director, and myself, the clerical services director. We have 4 family court judges. The presiding judge for family court is Judge Matthew Switalski. We have Judge Tracy Jokic, Judge Mark Switalski, and Judge Rachel Rensilli. Each judge has 2 referees assigned to their caseload, so there is a total of 8 referees at the Front of the Court. We have 11 judicial service officers servicing both the child support and parenting time department. We have 5 custody investigators and 5 child support investigators, 2 medical support specialists, and over 60 support staff that assist all the departments.
As I indicated earlier, for many of you, this may be the first time that you've been involved in any type of court process. So I think it will be helpful if you have a general overview of what the divorce process is about and just some of the basics of how that case will proceed. A divorce case is initiated by the filing of a complaint for divorce. And that is either going to be filed by an attorney that represents a party or a party that is representing themselves. And the divorce filing initiates the case, and it basically sets forth certain information about the marriage or the other type of family law matter that's being presented to the court. If you're representing yourself, you may hear the term in pro per. It basically means it's a Latin term indicating that you're representing yourself. You're in pro persona. Once the initial documents are filed with the court will issue a summons, and those documents are then required to be served upon the other party. And service can be achieved a number of ways. It's either a process server will hand deliver the documents to the other party. They can be served by certified mail. There are many ways that documents can be served, and there are various court rules that set forth that. Once service is made, the next steps of the case is there may be temporary orders that are done. Certain types of things can be entered at the outset of the case without a formal hearing, and those are generally temporary or injunctive orders. And by that, I just mean that the judge may, based on the information that's provided, enter a temporary order that generally preserves the status quo, that indicates that custody will remain as it is. That there will be preservation of the property or the financial assets, or that neither party would take adverse action by canceling insurance, things like that. The next step of the process then would be what's called the discovery phase of the divorce case. And early on in the case, once the case has been served, there will be a number of notices that are sent out to the parties. One will be for a status conference with the court, which is an initial scheduling conference that will set forth deadlines of how the case is going to proceed. If there are minor children involved in the case, the friend of the court will send out a notice scheduling a child support interview where each party will be required to submit their financial information so that the friend of the court can prepare a report for the court indicating what the Michigan child support guidelines call for based on the income of each party, based on the proposed custody arrangement of the children, and other factors such as health insurance, etc. Once the initial deadlines and schedule is set, really the next part of the case is about trying to negotiate a settlement. And that can be done whether you have attorneys or whether you're representing yourself. But the goal of any divorce case will ultimately be is to work through all of the pending issues. If there are minor children involved in the case, obviously issues about custody, parenting time, child support, and those type of things will have to be worked out between the parties. Friend of the court does play some function in that process, and we'll talk a little bit about that in more detail later. As the case progresses, there will ultimately be a subsequent conference with the court called a settlement conference. And that will be a little later on in the process where the court's going to get an update as to what issues may be resolved, what issues remain outstanding, are there any additional documents or evidence that needs to be shared in order for each side to prepare and ultimately resolve the case. Before any case goes to trial, and most divorce cases do not go to trial, they settle at some point. And that is either done through mediation, arbitration, or facilitation. At various stages, the court may direct the parties to meet with a third-party attorney to mediate the case. It's an informal process, it's non-binding, and basically it's an opportunity for the parties with their attorneys to sit down with the divorce attorney and to basically try and work through the issues of the case. That friend of the court also offers facilitation or mediation services, and that will be where the referees for the various judges will sit down with the parties, again in an informal setting, and try and work through the various issues that need to be resolved. In certain cases, the parties can agree to go to arbitration with an experienced arbitrator who's an expert in many areas of family law. And in arbitration, that would be in lieu of having the case go to trial before the judge. The arbitrator would essentially follow a bit more formal procedures and allow each party to submit testimony and evidence according to various court procedures, and the arbitrator would then make a determination as to how the divorce matters will be resolved. Ultimately, if that does not resolve it, there would be a trial that's set before the judge, and it would go through the formalities of having witnesses called, evidence presented, and ultimately the judge then would make a determination. Whether the parties with their attorneys or themselves resolve the matter and settle it through one of these processes, ultimately it results in the entry of a judgment of divorce. That's the final document that resolves all of the issues in the pending divorce case, and that's going to deal with all of the issues: property settlement, if there are minor children, the custody, parenting time, and child support provisions, and any other items that need to be addressed as part of that final resolution. The friend of the court, one of the functions they serve is we are the enforcement arm for collection of child support. And there will be something called a uniform child support order that is prepared and entered as part of the final orders of a case. And that will set forth, based on the child support guideline calculations, who will be the payer, how much is to be paid. We'll give a breakdown of what items they're paying for. And generally it results in a income withholding order being issued to a respective party's employer, and they will withhold child support payments directly from their paycheck. For people that do not receive regular paychecks, that are either self-employed or independent contractors, they will be responsible to make child support payments directly through the friend of the court, and we'll discuss those options and those payment mechanisms a little later on. The last thing in terms of the divorce basics process, there's generally two sections. There are prejudgment matters, things that happen before the case is finally resolved in a judgment of divorce or judgment of custody or other family matter judgment is entered. And then there are post-judgment. Once the parties are divorced, there may be problems that arise down the road or other disputes that arise, and the court does have continuing jurisdiction in cases that involve minor children until those children are no longer minors. So in prejudgment functions, the friend of the court does offer some services. We will provide initial investigations about child support, about custody and parenting time disputes, but otherwise we're limited in that. We don't administratively enforce the temporary orders while a case is pending. That would have to be done through your attorney, or if you're representing yourself, you'd have to file a motion asking the court to enforce any temporary orders. Once a case is finalized, however, and those final orders are entered, the friend of the court does have a number of administrative options available to enforce the payment of child support, to enforce the custody orders, and to enforce parenting time issues that are set forth in those final orders. And again, we'll be talking in more detail about that as we further explain the friend of the court process.
All right, so we're going to talk a few basics about child support. Your first contact with the friend of the court is likely going to be in the form of a support investigation appointment, and these are held with our support investigators. This appointment is required. Right now, during the COVID-19 pandemic, they're currently being done via Zoom or a teleconference call. Otherwise, once this is all over, you would be coming into the office and meeting with the investigator. So regardless of your intent to go through front of the court or opt out of our services, you are required to cooperate and attend this appointment and submit all the documentation that is needed. As far as opting out of front of the court, parties are eligible to opt out of front of the court services if there is no public assistance on the file. So that means mom, dad, and children are not to be on any kind of public assistance. Otherwise, you would be required to go through the front of the court. At this appointment, financial information is gathered by both parties. We look at tax returns, we look at household expenses, we look at any daycare expenses that are incurred for the children, any health insurance expenses that either parent may pay for. A lot of different factors go into the child support formula. It is a standard formula used by the Michigan courts. So really there's not much room for deviation. Whatever the formula calls out for is usually what the child support number is going to be. The judges will look at this recommendation when finalizing the divorce. The investigator may also issue two recommendations. If the parents do not have an agreement as to custody and parenting time, the two recommendations will be issued. A big factor in the child support formula is the average number of overnights that each parent may have with the child. So if there's no agreement at that appointment, the investigator will issue two recommendations based on both parties' requests. As far as post-modification for child support, post-judgment modification for child support, you are entitled to a child support review every 3 years. It is a free review that the front of the court will conduct as long as the parent sends a request to us. Those are the free child support reviews that are automatically done. You are entitled to file a motion at any time that there is a change in circumstance for child support purposes. The motion would be filed with the court and is typically heard by one of our referees, and then you would get a recommendation. The front of the court also has the option to petition child support to be reviewed on your behalf. This is usually done by a judicial service officer, and there's certain criteria that can be met that would allow you to have a petition done by the judicial service officer. Things like Social Security disability, SSI income, Veterans Affairs income. If you become unemployed and the recipient of unemployment benefits, that's also a reason we would petition the court to modify your support. Any workers' compensation claims that are pending, any PIP benefits that may be pending, or if one of the parents is incarcerated for an extended period of time. So the key is to keep front of the court posted on any changes in your income or employment status. That way, if a review needs to be triggered, the judicial service officer can petition the court on your behalf. Otherwise, you'll always have the option to file a motion to have your child support modified.
One important point about any modification of child support in particular is that it's very important that you notify friend of the court as soon as that change happens. If, for instance, if you're on unemployment, you generally cannot come back 6 months later and say, oh, by the way, I was unemployed during this time period. Unless both parties agree, the court does not have authority to issue a retroactive modification. So it is very important to reach out to friend of the court when a change occurs. And again, there are judicial service officers that you can present your information to. And if they're able to file a petition for you, they'll let you know that. If they're not able for some reason to do that, you'll generally be instructed to file a motion with the court so that you preserve that modification date going forward.
And the notice requirement is just as important in all circumstances, incarceration especially. We hear sometimes a year later that the other parent was incarcerated for a period of a year. And as Dave Falk said, we can't go back and modify it years back. So notice to front of the court is very important in having your orders established the way they need to be. So our next topic is custody investigations. As I stated previously, at the support interview, if custody and parenting time is at dispute, that investigator will issue an alternate recommendation based on both parents' requests. Now, the case can also go to our custody department, which could be referred by a referee or a judge. At that point, a custody investigator would interview both parties, would interview any witnesses that either party has, and may possibly interview the child or children over the age of 4. If custody is disputed and the referral is made to our custody department, there is typically a $500 referral fee for that facilitation and or investigation. Dave is going to talk to us a little more about the difference between the facilitation and the investigation.
Sure, and as part of that custody process, most of the time, a referee or judge will refer the custody investigation for facilitation to be followed by the investigation. And what that allows is this. The parties may not have to pay the $500 fee for the investigation if, with the help of the custody investigator, they're able to settle the issue or the disputes about custody or parenting time. Facilitation, again, is a voluntary process. It's informal. It doesn't require that you present witnesses and testimony in a courtroom setting, but it is a discussion with the custody investigator in this case to try and work through those issues. The investigator can give you their input based on what their determination of what's being presented to them. And if the parties are able to reach an agreement, the custody investigator will issue a report or recommendation indicating that agreement has been reached. They may also be able to assist with the preparation of an interim order that basically says this is how custody will be resolved. Again, it's a non-binding process, meaning the custody investigator is not going to force the outcome. They're only going to try and help the parties reach a resolution themselves. If they don't do that, then it would proceed to the next stage, and typically it's immediately after the facilitation appointment. If it's not resolved, then they would proceed with a formal custody investigation that would require the payment of the fee if it's not waived, and they will go through all of the factors that are involved in a custody determination and then generate a report and recommendation. Their report and recommendation is not a court order. So once that is issued, if a party objects to it, they may need to take certain action. If a party wants to adopt it, they may need to take certain action in order to reduce it to a court order or to take it on to the next stage.
So the next process that front of the court will handle is the enforcement process of our court orders. So once your case is finalized and we're in post-judgment status, the front of the court will enforce child support, any spousal support, medical support, custody, and parenting time provisions of that order. Now, the key to having front of the court assist you in enforcing your court order is that your court order reflects exactly what you guys are actually doing. So if you have any outside agreement as to child support or parenting time, once you deviate from the court order as signed by the judge, it really limits front of the court's ability to assist you in enforcing that order. So if both parents agree that they're going to deviate from the order and do something else for parenting time, it is very important that you also formalize that in an order and have a judge sign it, so that if there is an issue that arises in the future, front of the court is able to assist you by whatever the actual order is by the judge. Another important thing is that you keep front of the court updated not only on that, but any changes in your address, your income, your employment. The key to having front of the court assist you with anything that's going on, in your case, is that we're aware of what's going on. So you don't want to, tell us you moved 2 months after the fact. You want to make sure you get notices for all our hearings, all our appointments, and everything that goes on with the case. I'm going to hand it over to Lena. We're going to talk about child support collection and enforcement.
With regards to child support collection, the most common method used to collect support, and Referee Falk alluded to this earlier, is the income withholding order. Michigan law requires that child support be deducted from the child support payer's paycheck. So once a child support order is entered with a court, an income withholding notice will be sent to the child support payer's employer, telling the employer how much to withhold and where to send the payment. For some reason, if the employer does not do that, or if the child support payer is unemployed or not a W-2 employee, it falls on the child support payer to make sure to make the payments on time. The child support payer has various payment options available to them. For example, they can pay online using a credit card. They can pay at Pay Near Me locations, which are available at CVS, 7-Eleven, Family Dollar, MoneyGram. They can pay via MoneyGram at Walmart, Kroger, CVS again, or the payer of support can simply mail in a check or money order to the Michigan State Disbursement Unit in Lansing. If the payment method is going to be a check or money order, it is important that the payer include their case number on the payment instrument.
And one thing we'd like to add is, with child support payments, it is a monthly obligation. There's no specific due date per se. As long as the payment is received in full by the end of the month, the payer is considered compliant with their court order. So a lot of times, somebody may be a bi-weekly payer because it's being garnished from their paycheck at a bi-weekly basis. If for some reason the employer sends it a little late or something like that, you're not necessarily late in your payment unless the 30 days has passed. So I always try to remind people, it is a monthly obligation, but it is not due on the first of the month. As long as a payment is received in full by the end of the month, the payer is in compliant with their court order.
So once a file gets on the radar of a JSO, meaning it has arrears, the JSO typically will send a warning letter to the payer of support telling them that they have 21 days to contact the front of the court, let us know what's going on. If the warning letter doesn't serve to get the file back on track, the JSO then will typically set what's called a show cause hearing, where the payer of support will need to appear or participate remotely and explain why they have not been paying their child support. Normally this ends in a resolution. However, if not, the next thing the JSO would do would be to set a subsequent hearing with a judge assigned to that file. The judge will hear the matter, and the judge has the authority to sentence the payer to up to 90 days in jail. A few other things that could happen to those who don't pay their support is they could have their name submitted to the credit reporting agencies once their file hits 2 months worth of arrears. They could have their bank accounts levied, their tax refunds intercepted. Additionally, once the threshold of $2,500 in arrears is met, they will be prohibited from renewing their passport. So it is important to make sure that that the payer is monitoring their pay stubs and making sure that their employer is submitting their payment in full and on time. If not, the payer will need to make sure to make the payments on their own using the various payment methods available.
And I just want to clarify the importance of attending a show cause hearing. Just because the hearing may be semi-informal and with the JSO rather than the judge at first, it is important that the non-custodial parent especially participates in the hearing, because failure to appear or participate via Zoom in a show cause hearing may result in a warrant for the payer's arrest. And it's a whole different enforcement process once the warrant is out there. Another thing to note is if the payer of support happens to move out of state, it doesn't mean that the front of the court won't enforce anymore. We do have the ability to have the other agency in the state where the payer moved to possibly help enforce support. So just because the parent leaves the state of Michigan doesn't mean that support just lingers out there until he or she comes back.
And the other thing to note is it is very beneficial for the payer to participate and appear at a show cause hearing, because they have the opportunity then to explain what's going on with their financial circumstances. And the JSO, if necessary, can submit a petition or a request to have the child support order modified. Because there are thousands of cases here in Macomb County, each judge has an enforcement team assigned to help them make sure that their orders are being followed. So for child support, each judge has 2 judicial service officers and a parenting time judicial service officer. Again, their role is to make sure that the court orders are being followed.
Each case has a medical support specialist assigned to their case to enforce the medical provisions of the Uniform Child Support Order. A Uniform Child Support Order has provisions that orders one or both parties to maintain health insurance for the benefit of that child. It also requires the non-custodial parent to pay a monthly premium towards any ordinary medical expenses. There is also a deductible amount that the custodial parent needs to meet, which is kind of like a threshold, before the expenses get split into a percentage between both parents. That percentage is also on the Uniform Child Support Order, which would cover anything that's not covered by insurance once it meets a threshold amount. For example, for one child, the amount is $403. Once that amount has been met, the parents would split it into a percentage. If the other parent is not reimbursing mom or dad for their portion, they may submit their documentation to the front of the court showing what the expenses were, that they've reached out to the other parent for reimbursement, and that parent has failed to reimburse the other parent. At that point, the medical support specialist will start the process of enforcing for reimbursement. Possible sanctions may also be a show cause hearing for contempt for failing to pay towards that reimbursement, or even maintaining health insurance for the child. Another big topic for front of the court as far as enforcement is parenting time. There's a misconception that front of the court enforces just child support, but as you've seen, we enforce child support, we enforce the medical support, but we also enforce parenting time. Front of the court also enforces parenting time provisions and custody provisions of the court order. Denials of parenting time includes denying parenting time to the parent. The parent who has been denied parenting time must attempt pickup of that child. I always tell parents, if parent A tells you they're going to deny parenting time and you don't attempt to pick up the child, you're conceding to not having parenting time at that point. You must actually attempt pickup of your child and then file a complaint with the front of the court. Complaints may be done in writing via email or fax, regular mail, or we have online submission forms where you can fill out your denial. The denial is then reviewed by the judicial service officer for enforcement. Other provisions of parenting time that we enforce are failure to return the child, any change of domicile violations, meaning the parent moves out of state without the court's permission, excessive tardiness for parenting time. I always tell people we have a little bit of a grace period in being late for the parenting time pickup and drop off, but if it becomes excessive, it becomes a problem and the order may need to be modified. We also enforce joint legal violations. This means a change in the child's school district, any doctors or medical appointments without the other parent's knowledge, consulting with medical doctors about diagnoses and not letting the other parent know. The key to joint legal agreements is to keep both parents informed on what's going on with the child. Enforcement remedies for parenting time, which are most common, are 21-day letters. What this means is the judicial service officer receives a complaint that parent A has denied parent B parenting time. So we'll send a formal letter advising the parent that a complaint has been filed and that you have to owe the other parent make up parenting time. Usually the parent will either offer the makeup parenting time or send a letter back to the JSO advising why they denied parenting time. If a resolution is not met by a 21-day letter, the next possible remedy that the JSO can do is have a show cause hearing. It is very similar to the child support show cause hearings. They are contempt hearings that can go before a judge. Some remedies that come out of these show cause hearings are changing the actual parenting time order, makeup parenting time, or even possible incarceration for continuing to deny the parenting time. The JSO also conducts joint meetings. These are voluntary appointments that both parents would attend. Right now, we're currently conducting them via Zoom. And what the JSO does at these joint meetings is try to reach a resolution on small issues in the parenting time order, such as possibly modifying the pickup and drop-off time. At the conclusion of these appointments, an order can be entered, a consent order between both parties. We do a lot of joint meetings right now, especially with the COVID pandemic that's out there, so you could be participating via Zoom. So non-enforceable issues of parenting time. Dave will also help me with this because a lot of it falls sometimes into the laps of referees because the parents will file motions. But front of the court's not going to enforce extracurricular activities or sporting activities, communication issues, child's not answering FaceTime call, things like that. Children's belongings is something front of the court also does not get involved in. We always tell parent A and B that they should have enough clothing, food, diapers, formula, whatever it may be for the child during the duration of that parenting time. Just because front of the court doesn't enforce it doesn't mean it's not a non-enforceable issue. It just means you would have to file a motion with the court and talk to one of our referees.
And that brings us to the referee department within the friend of the court. There are 8 referees that make up the friend of the court referee department. Brian Nicholas is the chief referee. Each judge is generally assigned 2 referees to primarily work on their docket, but all of the referees do have some crossover depending on docket schedules, depending on availability, workload. Any particular judge's matter could ultimately be assigned to any referee to resolve the matter. In a general sense, while a case is first pending, it's very common that the referees will be involved in hearing initial motions before they go to the judge, or conducting other hearings as directed by the judge to address certain issues of a case. The referees, we are not judges. We're there to assist the judge, and while we do conduct what appear and are very much like a trial of the issue, the result of it is one of 2 things. Number one, through our involvement with the parties and their attorneys, if they're represented, we either are able to get an agreement with the parties and reduce that agreement to a court order, which will then be entered by the court. But if that does not happen, we then conduct the evidentiary hearing or other hearing as directed by the judge, and we issue a recommendation. That recommendation is still subject to review by the judge and would have to be either objected to or adopted by the judge in order for it to become an order. So most commonly on motion day, which is Mondays in Macomb County, most of the motions that are referred to referees are going to be heard at the front of the court building, which is immediately next door to the circuit court building. In our current situation, the building is not open to the public, and we are conducting all of those hearings via Zoom. For evidentiary hearings, again, we're also conducting those by Zoom right now. And those could deal with issues about modification of child support, modification of custody, modification of parenting time. And again, if we do conduct a hearing because the parties have not reached an agreement, we would issue a report and recommendation advising the court of what our findings were, what evidence was presented, and what our recommendation for the court order is. Again, if either party disagrees with that recommendation of a referee, they do have the ability to file an objection and have what's called a de novo hearing or a judicial hearing in front of your judge to make a final determination on that. Your friend of the court, the PowerPoint presentation does give a breakdown of the current assignments of, depending on who your judge is, indicates what referees are primarily assigned to your matters. The only other point that I would make that I think would be helpful in terms of dealing with the referee department, whether it's before the judgment's entered or it's post-judgment, especially when people are representing themselves, is that the friend of the court referees are not advocating one position for one party or the other. We're simply there as a representative of the court and assisting the judge in trying to determine what the issues are and what the resolution will be. It's up to the parties to present the evidence, the witnesses, and any other information that's necessary in order for the court to make a determination. I was referencing at the very beginning of our program that one of the friend of the court's functions is we're an investigative agency, but it's only in the context of the pending case or issue before the court. Many parties will file a motion indicating that the other party is engaged in inappropriate conduct, alleging they're causing harm to the minor child, or other potentially criminal acts. And friend of the court is not the once the allegation is made, it is up to the parties to either have law enforcement conduct an investigation if it's appropriate, so to file the complaint with law enforcement, file a complaint with protective services, or otherwise produce the evidence and the witnesses necessary to present that information to the court to make a determination. Unfortunately, many parties feel that all I need to do is let the court know that parent A is doing something wrong, and it's up to the court to figure it out and to take appropriate action. The court has to balance the right of both parties as well as the minor children in the matter, and that oftentimes presents a difficulty. So I think if parties understand what the role of the friend of the court is, that it will be helpful in not frustrating them through that process if they know what's expected of them. So that's a quick overview of the referee department at friend of the court.
And I just wanted to leave everyone with a few tips. So when parties are contacting their friend of the court, they should always make sure to reference their case number, whether they're calling in or emailing in. Parties have to make sure to keep the friend of the court updated with any changes in regards to their address, their phone number, employment status, medical insurance. Also, we understand here at the front of the court that tensions can run high when dealing with family matters, but it is important to remain calm so that you're able to communicate your concern to the front of the court staff when you're calling in or writing in, and so that we're more able to effectively assist you. Any correspondence or any communication between a party and the front of the court staff will be documented in the file. Please be kind, please be patient with us. We want to help you, we're here to help you. Right now, during the COVID situation, response times might be a little bit longer than usual, but we are working on that. Pretty soon we're going to have a system where parties can virtually meet with their judicial service officer. That is in the works, so we're looking forward to that. As far as resources go, there's plenty of information available online with regards to the subject of divorce, but people do need to make sure that the information that they're getting online is valid and current. I would always say visit our website, and it has a lot of information with regards to custody, parenting time, child support. It has a lot of forms on there that people might need to make changes to their court order. Also, MichiganLegalHelp.org is a fantastic website. And the My Case website is also a fantastic tool. It's where parties can go to access all of the information regarding their child support case.
One point that I just highlight from what was indicated, probably the most important thing that the parties can do, or one of the most important things, keep your contact information updated with friend of the court. Whether you had a divorce case, a custody case, or some other family law case, your final paperwork or judgment in that matter, one of the provisions of that paperwork is that you keep your information current. If you do not, many people don't know that if the other party subsequently wants to file a motion or raise a complaint, friend of the court is only obligated to give notice by mailing a notice to the last known address of any party that has a friend of the court matter. So do yourselves a favor by keeping that information updated, as well as other contact information. Now it's very important, while we're doing things remotely and hearing motions by Zoom hearing, it's very important that we have current telephone numbers and email addresses. It's just another way that we can keep in contact with you to advise you of anything that may be pending with the friend of the court.
And I just wanted to close to remind everybody that, you know, things do look a little different around front of the court right now with the COVID situation. We are doing things remotely. We're still closed to the public. We will have a online check-in system once we do reopen to the public, so you can look out for that. Always look at our website. It'll have up-to-date changes on how we're operating, what's new and what's happening. As Lena stated, we're also going to be launching a virtual check-in system, so you can talk to your JSO via Zoom or Google Meet or whatever it may be. COVID is a very fluid situation, so it does change daily, as you can see, so always visit our website for any updates and changes. Thank you for watching this video. I hope you guys got some information that's going to be very helpful as you go through this